Television dramas portray it as the ultimate legal loophole, a clever trick used by cunning defendants to escape justice. Yet, in the actual American legal system, the insanity defense is raised in less than 1% of all felony cases, and it fails in roughly 75% of those attempts. It is not a get-out-of-jail-free card, but rather one of the most rigorous, misunderstood, and controversial mechanisms in criminal law. The defense forces a courtroom to grapple with a profound philosophical question. At what point does a severe mental defect erase a person's culpability for a horrific act? To understand this defense, one must first look at the foundational architecture of criminal justice. For a crime to occur, the law generally requires two concurrent elements, the Actus Reus, or the guilty physical act, and the mens rea, which translates to the guilty mind. A person must not only commit a prohibited act, but must do so with a conscious criminal intent. If a severe cognitive impairment obliterates that intent, the core justification for punishment collapses. The insanity plea asserts that the defendant lacked the mental capacity to form that necessary guilty mind, making them legally blameless despite causing tangible harm. Navigating this assertion introduces a massive collision between two entirely different disciplines. Psychiatry seeks to diagnose and treat mental illness, exploring the nuances of human behavior. The law, conversely, seeks to assign blame, protect the public, and maintain strict societal order. In a courtroom, medical insanity and legal insanity are completely different concepts. A defendant can suffer from profound, documented schizophrenia, experience severe hallucinations, and still be found legally sane. The judicial system requires proof that the mental illness directly incapacitated the defendant's moral reasoning at the exact, precise moment the crime was committed. The blueprint for this strict legal threshold was drawn nearly 2 centuries ago in London. In 1843, a Scottish woodturner named Daniel M'Naghten attempted to assassinate the British Prime Minister, driven by intense paranoid delusions that the government was actively persecuting him. He mistakenly shot and killed the Prime Minister's secretary instead. During his highly publicized trial, medical experts testified to his severe delusions, and the jury ultimately found him not guilty by reason of insanity. The resulting public uproar reached the highest levels of the British government, forcing the House of Lords to establish a rigid legal standard for all future cases. That standard became known as the M'Naghten Rule, and it remains the bedrock of insanity defense law in roughly half of all United States jurisdictions today. The rule asks two highly specific questions. First, did the defendant suffer from a severe mental disease or defect at the time of the act? Second, and most crucially, did that defect prevent them from knowing the nature and quality of their act, or from knowing that the act was wrong? If a person believed they were squeezing a lemon rather than strangling a victim, or if they knew they were strangling someone but genuinely believed a divine entity commanded it to save the world, they might meet this strict criteria. The principles from that foundational 19th century case never faded. It creates an incredibly high bar, requiring nearly total cognitive failure. Critics argue it is an antiquated test that ignores decades of modern neurological and psychological advancements, focusing entirely on pure logic and ignoring a person's emotional state or their ability to control their impulses. Yet, the legal system clings to it precisely because it is narrow. It provides juries with a definitive binary question in an area of human behavior that is otherwise drowning in complex shades of gray. When a defendant invokes this defense, the standard mechanics of a criminal trial are turned completely upside down. Normally, the prosecution holds the absolute burden of proving guilt beyond a reasonable doubt. But when insanity is claimed as an affirmative defense, the burden often shifts. The defense must actively prove the defendant's mental incapacity. This transforms the courtroom into an intense battle of expert witnesses. Psychiatrists and psychologists are brought to the stand, dissecting the defendant's medical history, brain scans, and behavioral patterns, attempting to reconstruct the fragile, invisible state of a human mind during a violent event. The jury is then left to untangle highly technical, often conflicting medical testimonies to reach a legal conclusion. If they are convinced, the resulting verdict is not a sudden release back into society. A verdict of not guilty by reason of insanity almost universally triggers an immediate, involuntary commitment to a maximum security psychiatric facility. The individual transitions from the jurisdiction of the penal system to the jurisdiction of the mental health system. They are confined until a judge and a panel of medical professionals deem they are no longer a danger to themselves or the public. This reality of indefinite confinement is rarely recognized by the general public, leading to deep societal suspicion whenever the defense makes national headlines. The tension between public safety, psychiatric treatment, and legal accountability eventually reached a boiling point in the late 20th century, an event that fundamentally rewrote federal law. In 1981, John Hinckley Jr. shot and severely wounded President Ronald Reagan, a Secret Service agent, a police officer, and Press Secretary James Brady outside a Washington hotel. The assassination attempt was captured on television, horrifying the nation. During the subsequent trial, Hinckley's defense team argued he was driven by a severe psychotic obsession with a famous actress, living in a delusional world where the assassination would magically win her affection. At that time, federal law placed the burden on the prosecution to prove the defendant was sane beyond a reasonable doubt. Given the extensive, highly detailed psychiatric testimony regarding Hinckley's schizophrenia, the prosecution simply could not meet that monumental burden. The jury returned a verdict of not guilty by reason of insanity. Hinckley was immediately committed to a psychiatric facility where he would remain under strict supervision for decades. The verdict ignited an absolute firestorm of public outrage. Citizens and lawmakers alike felt that a man had attempted to assassinate the leader of the free world on camera and had somehow evaded justice through a medical technicality. The backlash was swift, severe, and transformative. The echoes of that landmark decision still resonate through the halls of Congress and state legislatures across the country today. In direct response, Congress passed the Insanity Defense Reform Act of 1984. This legislation drastically altered the federal landscape. It eliminated the prosecution's burden to prove sanity, placing the burden squarely on the defendant to prove insanity by clear and convincing evidence. Furthermore, it stripped away the volitional prong of the defense that had existed in some federal courts, which had previously allowed defendants to argue they knew an act was wrong, but simply lacked the physical power to control their impulses. The new law returned federal courts to a strict cognitive standard closely mirroring the original standard from 1843. State legislatures quickly followed suit, tightening their own definitions of criminal responsibility to prevent similar public outcries. Today, the legal landscape is a fractured patchwork of differing standards. While many use the classic cognitive test, others employ the model penal code standard. This is slightly broader, allowing a defense if a mental disease prevented the defendant from appreciating the criminality of their conduct or conforming their behavior to the law. Alternatively, a handful of states, including Idaho, Kansas, Montana, and Utah, went even further, abolishing the insanity defense entirely. The outright abolition of the defense in these states eventually reached the highest court in the land, raising profound constitutional questions about cruel and unusual punishment. In the 2020 case of Kaler v. Kansas, the Supreme Court was asked whether the Due Process Clause of the 14th Amendment requires states to offer an insanity defense. The court ruled that it does not. The justices determined that while states must consider a defendant's mental state regarding their intent to commit the crime, they are not constitutionally mandated to adopt a specific moral incapacity test. This ruling cemented the immense power individual states hold in defining the boundaries of justice and mental illness. It underscored a harsh reality of the American legal framework. The constitutional right to a fair trial does not guarantee the right to be judged by one's medical reality. The law prioritizes objective societal rules over subjective neurological states, allowing states to punish individuals who may not fully comprehend the moral gravity of their actions. For those who do successfully navigate this labyrinthine defense in states where it remains, the aftermath is fraught with its own unique, severe consequences. Studies show that individuals found not guilty by reason of insanity often spend twice as much time confined in psychiatric institutions as they would have spent in a traditional prison had they been convicted of the underlying crime. There is no parole board, no fixed sentence, and no good time credit. Freedom is entirely dependent on proving the complete absence of a dangerous mental illness, a standard that can be nearly impossible to meet. Ultimately, the insanity plea sits at the uncomfortable intersection of medicine, morality, and law. It forces society to acknowledge that while human actions can be monstrous, the human mind is fragile and susceptible to profound malfunctions. The legal system, built entirely on the premise of rational actors making free choices, struggles deeply to process individuals whose rationality has been hijacked by disease. The defense remains a rare, vital, and deeply flawed mechanism. It serves as a necessary safety valve for a justice system that refuses to permanently imprison those who truly cannot comprehend their own actions. Yet, its strict application ensures that only the most profoundly incapacitated ever see its protection. As our understanding of the human brain continues to evolve, the legal definitions of sanity, responsibility, and justice will undoubtedly face new challenges, forcing courtrooms to continually redefine what it actually means to possess a guilty mind.